Good afternoon. Thank you for joining us. Holtzman, I chair the employment law practice here at Krokidas and Bluestein. I want to welcome you to our webinar on the Department of Labor's new overtime rules, with a particular emphasis on the implications of these rules for nonprofit employers. We have a full-service employment law practice here at the firm, and I want to just mention some of the areas that we're dealing with on behalf of our nonprofit clients. We're privileged to represent a wide range of nonprofits across the human service sector and others as part of our practice. The employment law issues that we're seeing regularly include the following: wage and hour issues, which we're going to be discussing today, particularly as it relates to overtime, but we're also having a lot of issues come up around misclassification of employees as independent contractors, issues around off-the-clock work, meal breaks, minimum wage compliance, the new earned sick leave statute in Massachusetts. Also, for the last few years, I've been dealing on behalf of nonprofits and others on the issue of proper use of volunteers and interns. Family and medical leave issues are perennial. We're also dealing regularly with issues of discrimination, harassment, and disability accommodations. These areas, as many of you know, we like to be involved proactively in assisting you in making employment decisions to avoid claims. So that's a counseling role that we play for our nonprofit clients. Other areas that we're seeing claims in and questions coming up have to do with whistleblowers, discipline decisions whether to terminate, negotiation of severance agreements, employee handbooks, drafting employee handbooks, updating them to reflect the latest requirements under state law and federal law. In addition, we work with our clients to investigate complaints that are received, whether they involve discrimination, harassment, or other employment law issues. We do audits on compliance, and we also are happy to have opportunity to train your supervisors regarding topics such as wage and hour compliance, progressive discipline, and prevention of harassment. So that's just some background on the employment law services. Generally, I want to focus today on the Fair Labor Standards Act, and particularly the issue of overtime pay. Before we get into the new rules, I want to give a little background about why we're here in the context for the new rules. The Fair Labor Standards Act requires that most employees be paid first at least the federal minimum wage for every hour they work, as well as overtime pay at a rate of time and a half their regular rate for all the hours that they work over 40 in a given work week. Often get the question whether that involves that obligation can be triggered by somebody working more than 8 hours in a particular day. The answer is no. The test is on a weekly basis, and it's 40 hours. Importantly for today, the Fair Labor Standards Act allows for certain exemptions from these overtime and minimum wage requirements. These exemptions apply to certain employees who work in administrative positions, professional positions, executive positions, highly compensated employees, outside sales employees, computer professionals. These employees are known as exempt employees, meaning that they are exempt from the obligation that you pay them overtime. However, to be considered exempt, an employee has to satisfy 3 general tests that focus both on how the employee is paid and, critically, on the type of job duties that they perform. So just by way of introduction, the 3 tests are these. The first is what's called a salary level test. As of December 1st, employers will need to pay an employee at least $913 per week to qualify for the 3 key exemptions, the most common exemptions, which are the executive, administrative, and professional employee exemptions. That's the equivalent of about $47,000 a year. But that's not enough. In addition, the employee has to be paid on a salary basis, meaning that they get their full salary any week, regardless of the quality of their work, the quantity of work, meaning the number of hours that they work. So they are a salaried employee. Now, I want to pause on this one because the most common misconception in this area of overtime law is that the term salaried is synonymous with exempt from overtime. It is not the case that everyone who is salaried is exempt from overtime, and that is because the 3rd test is the key one. It's the duties test. In addition to having been paid a salary that's high enough, having been paid a salary consistently on a salary basis, you've got to meet the duties test. And we have to look at the primary duties of the particular employee and hold them up against the regulations that have laid out these exemptions and opinion letters that have been issued by the Department of Labor, court decisions implementing and interpreting these exemptions. That's the background. Let me focus first on this new set of rules that are going into effect December 1st. As I said, they're going to raise the salary level requirement. It's currently $455 a week, about $23,000 a year. New rate $913 a week, $47,476 per year. They set that by measuring the 40th percentile of weekly earnings for full-time salaried workers in the lowest wage census region in the country. Another important change made by these rules is that the category of highly compensated employees is being redefined as well. It used to be a nice round number, $100,000 per year. It's now going to be $134,000. That's pegged at the 90th percentile for full-time workers nationally. These are significant changes. We're going to talk about options you have to implement them and the implications. But one of the first questions we often get is how and when, or when to implement them. So they take effect December 1st. As many of you probably noted, that's the middle of a week. Not an ideal time to implement any sort of payroll change. So the recommendation generally we give to clients is you think about doing it the week before. It's Thanksgiving week, give you an opportunity to do it on a full week basis. It's a week in which it is very unlikely you're going to have employees working overtime. And it gives you, as I say, an opportunity to do a dry run and make sure you've got everything in place for the actual legal effective date the following week. These threshold numbers, salary minimums that I mentioned, are actually going to be updated every 3 years. The Department of Labor will publish them in advance. The first update will come in 2020 on the 1st of January. Our best estimate is that one will raise the rate to $984 a week, or about $51,000 a year. And that highly compensated figure will go up to almost $150,000. So this is meant to address a criticism of the law, which was that it was stuck in place and had not been updated for an extended period of time. Here, by building in the automatic updates, the idea is that these minimums will keep pace with inflation and wage rates more generally. In thinking about how you establish one of your employees meets these new minimum salary thresholds, the new regulations give you some options in addition to the basic salary. You can count commissions, you can count bonuses that are non-discretionary, meaning they're to be paid automatically, and you can count incentive pay to get to those thresholds. If you're going to make upward salary adjustments, if you're going to increase the salary for some of your employees in order to confirm that they meet the exempt status requirement, you're going to make sure that that's done before December 1st, 2016. They're exempt now, but their salary falls between the current threshold and the new one. Again, you've got to make that increase before the 1st of December. And think about the fact that many employees are on a biweekly payroll pay schedule, so you're going to make sure that you hit the right pay period. Some basic options here in thinking about how to address the new regulations and what your options are. First is, if you've got an employee who, because of the new threshold, is no longer exempt, they fall into what's called the non-exempt category, meaning they are entitled to overtime. You could leave their compensation exactly as it is and simply pay them time and a half for working overtime. You'll need to maintain pay records and ensure that, time records, and ensure that you are tracking their time accurately and paying them at the time and a half rate for any hours over 40. That's option one. Second option is to raise the salaries or the total compensation, again, including the commissions and the others, if those apply, incentive pay. But this is a solution only if the employee also qualifies for an exemption based on the duties. This is where that misconception is so dangerous. Many employers for many years have figured anybody who's salaried is exempt, I don't have to worry about overtime, and have never looked beyond that to see whether they met these duties tests. So if you were such an employer and you thought that therefore all you needed to do to meet the requirements of the new rules is to raise the salary, you would be at significant risk, because there is this what I'll call the duties gap in addition to the salary gap. It's simply not enough to hit the salary minimum. You've got to be sure that each employee, each job classification satisfies one of the exemptions based on the actual duties performed. Okay, so category 2, option 2 is to raise the salaries. The third option would be to ensure that managers are enforcing a rule which limits employees' hours to 40 hours per week. Easy enough to put that on paper. The trick obviously is in the enforcement and in the oversight. Important point here, if employees violate that policy, in other words, they work more than 40 hours a week, you're going to be obligated to pay them for that time. However, an employee who is consistently out of compliance with that and is not obtaining advance permission, for example, from supervisors, if that's required, can be disciplined for violating that rule just as they could for any other workplace rule. So you can deal with it as a disciplinary matter, but in the meantime, keep in mind that if there are violations, people work over 40, they got to be paid in the meantime. Another approach that some organizations are taking is to look generally at the workload of the different employees in different departments. Think about distributing the tasks, the responsibilities, the areas of work to ensure distribution that minimizes the likelihood that any single employee is going to have to work overtime. Massachusetts law on overtime generally tracks the federal requirements, but it's important to note that compliance with overtime laws is particularly significant for a Massachusetts employer because the penalties, the punishment, is particularly strict here, and it's stricter and more vigorous than the federal law. In particular, in Massachusetts, any violation of any wage and hour law, including the overtime law, will lead to an automatic or mandatory award of what are called triple or treble damages. So if an employee is owed $100 in overtime pay, that automatically becomes $300. In addition, these cases we have seen can be filed as and certified by a court as what are called class actions. If an individual employee or a number of employees are able to convince a court that they've been subject to a common policy or practice, their claims are typical of those of 50 or 100 or 200 other employees in the organization, the case can be expanded to cover the claims of all of those employees. Implication obviously is your damages and exposure are going to be multiplied quite rapidly. How do you avoid this? Answer is ensure that you're in compliance and that you're keeping up to date with the new regulations, these new thresholds, but particularly that the duties tests are met for your employees and that you've got policies in place that are compliant with the state and federal overtime requirements. Question under Massachusetts law as to how far back employees can claim overtime pay. The answer is typically 3 years. In addition, employees who prevail are entitled to interest on the wages from the date those wages were owed, as well as their attorney's fees. So I'm thinking about the cost of compliance. The comparison ought to be the worst case scenario. If you're out of compliance, you're going to end up paying not only for your attorney to defend you in a case, but if the plaintiff were to prevail, you will pay for the plaintiff's attorney's fees as well through what's called fee shifting. This is contrary to most lawsuits where each side bears their own costs. This, like discrimination law, Chapter 151B, the wage and hour laws have a fee shifting provision which are meant to encourage attorneys to bring cases in these areas. So that has to be factored into your calculation, your assessment. Okay, specific to nonprofits. Often are asked, are nonprofits covered by the Fair Labor Standards Act? The answer is nearly certainly yes. And that's because there are 3 different ways in which they're going to be covered. First is in Massachusetts, as in a number of other states, these regulations are going to apply to all employers and all employees. Secondly, you're going to be covered on the federal basis, likely because of your organization's called enterprise coverage. If you've got annual revenues of at least $500,000, you're an enterprise that falls under the ambit of the Fair Labor Standards Act. But most importantly, whether or not, if you're a small organization, you may still be covered because the individual employees may be covered. So even if somebody's employer doesn't meet the standard for enterprise coverage, that employee may be covered if they are engaged in interstate commerce, in the production of goods or services for interstate commerce. So this can be activities such as regularly making out-of-state phone calls, receiving or sending mail or email from out-of-state, ordering goods from suppliers out-of-state, handling credit card transactions. Not a difficult threshold to meet. So assume coverage. Assume that you're covered by the Fair Labor Standards Act, and let's talk about how to be sure you're in compliance. In compliance if your employees meet one of the exemptions. Talked about the salary test. It's got to be a predetermined and fixed minimum. They have to be a salaried employee. If somebody is paid on an hourly basis, at the end of the discussion, they cannot be exempt. The duties test is where we're going to focus. But before we do, I want to go back to this highly compensated employee test for a moment because we talked about the new threshold. The figure will be $134,000, but there are two other elements. That employee has to perform office or non-manual work, and they have to perform customarily and regularly one of the tasks or duties that fall under the executive, administrative, or professional exemptions. We'll look at those in a moment. That's a much less rigorous test. They don't have to meet all of the requirements to be an executive, administrative, or professional, just one of them, plus this high level of compensation and office work. Okay, the first exemption is the executive exemption. To meet it, you've got to satisfy each of the following tests. Talked about the salary basis. $913 a week is the new minimum salary. And here's where we get into the actual duties. Their primary duty must be managing the enterprise, your organization, nonprofit or for-profit, it's the enterprise, or managing a department or subdivision of your organization. To be an executive, that employee has to regularly, customarily, not on a sporadic basis, but as a regular part of their duties, direct the work or supervise at least 2 or more other full-time employees, or the equivalent. But before half-time employees, the equivalent to FTEs, full-time employees. Pause here to note that it's not enough to put on paper or in a job description that somebody supervises 2 people. They actually have to do it in practice on a regular and customary basis. In addition, they have to have the authority to hire or fire other employees, or at a minimum, their suggestions and recommendations as to hiring or firing or promotion must be given particular weight. So that's consistent with being somebody's supervisor, but it doesn't always overlap that way. So you've got to meet each of these 4 requirements for an employee to meet, to satisfy and qualify for the executive exemption. I should have mentioned at the outset, you have a questions box on your screen. And if at any point during our webinar you have a question, please feel free to enter it there. They'll be visible just to me, not to the other participants, and we'll try to address as many as we can at the end of the webinar. Second exemption is the professional exemption. Qualify for this exemption, all of these tests must be met. Same, have to be paid on a salary basis, $913 a week, and then we turn to the duties. For this exemption, your employee's primary duty must be the performance of work requiring advanced knowledge, just defined as predominantly intellectual work, could be and includes work that requires the consistent exercise of discretion and judgment. Advanced knowledge has to be in a recognized field of science or learning, and this advanced knowledge has to have been customarily be acquired by what's called a prolonged course of specialized intellectual instruction. So there's a lot of case law on this. There's a lot of opinion letters. We're talking here about folks who have advanced degrees, master's degrees, or other learning that could satisfy these exemptions. So it might be nursing, it might be social work, but these are categories of employees who may well qualify for this professional exemption and therefore be exempt from the requirement of being paid overtime. Next categories are creative professionals. Same salary minimums. Here we're talking about people whose duty requires invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. For most of you, this might not be relevant. You might have communication professionals, public relations professionals, conceivably, possibly web designers might meet this exemption. There's a separate exemption for computer professionals, particularly those involved in coding and high-level computer work, which is worth considering as well if you have employees who are designing systems or involved with systems analysis, software, and programming. Not your computer techs, that's not going to satisfy that exemption, but higher level computer professionals. This next one is a popular exemption in the sense that many of your employees may well qualify for it. It's the administrative exemption. Same salary minimum, have to be paid on a salary basis, but here the primary duty has to do with the performance of office or non-manual work directly related to the management or general business operations of the employer or your customers or clients. Note there's no requirement that these folks supervise any particular number of employees, but the third requirement is the critical one here. Their primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So we're looking here at two elements within this prong. First, discretion and judgment, but it can't be just discretion and judgment about just anything, right? Deciding who gets access to the petty cash is not going to be sufficient because that's not a matter of significance. The courts and the Department of Labor is going to look at both of those pieces. Give you an example. Some schools have admissions office staff. Some admissions office employees have been held to be exempt under this administrative exemption because they're involved in setting policy and higher order work. Other administrative admissions office staff who simply are responsible for handing out pamphlets or keeping track of applicants or more ministerial tasks with the same job title, admissions office staff, they've been held not to satisfy the exemption. So we're looking at whether there's discretion and independent judgment, meaning are they following a template? Are they doing the same thing every day that somebody has directed for them? Or do they have the discretion? Do they have the ability to make decisions on their own about matters of significance to the organization? We've talked about the highly compensated employee exemption. I want to go to a question that we get frequently, which is, I've got an employee who doesn't meet the new salary threshold. I want to raise their salary, but I don't want to end up paying them more. I know they work some overtime, and I'd like to calculate a formula I'm referring to as a cost-neutral basis. I'll go through this because it is possible, and I'll tell you what the formula will be, but I want to highlight a major flag, which is this is not a solution that works unless you have a predictable number of overtime hours. But let's talk about what you'd do if you had such a person. You've got an employee who is now non-exempt because they don't meet the salary minimum. They would be exempt otherwise. They meet the duties test. They work more than 40 hours a week. Here's what you might do. You might drop their base pay rate, allow that person to make up for the shortfall by receiving overtime pay. Perfectly legal. The question that comes up is, what's that pay rate? How do I peg it? So when they work their overtime, the total compensation is going to be neutral, same as what they've been earning. It's possible to calculate this. Here's the formula. The weekly salary divided by 40 plus the product of the number of overtime hours times 1.5. So you can come up with such a figure. Here's how it would work. You've got somebody who you know works 45 hours every week. The weekly salary is $800. You look at their hourly pay rate, and this is an important point, everybody has an hourly pay rate, whether they're salaried or hourly. You calculate it by dividing their weekly rate by 40 hours. This person's overtime rate is $30 an hour, which is 1.5 times the base rate of 20. They in fact do work 45 hours per week. The person would make $950 a week. Use the cost-neutral formula as working 45 hours a week. Base weekly pay rate would be dropped to $16.84. There's the formula. That's how we got to the $16.84. Would mean that this person's overtime rate is going to be $25.26. Again, that's 1.5 times their base rate. Individuals' weekly take-home pay now for their 40 hours of work is going to be $800 again. Oh, sorry. But, excuse me, it'll be calculated differently. It's going to be $16.84 times the 40 hours, and then 5 overtime hours will be paid at that $25.26 rate. Again, unless this employee reliably is working 5 hours of overtime a week, could be earning less than he was earning before, right? If they're working more than 5 hours, they're going to be paid less. So this option, and you're going to have an employee with going to be less than pleased. So again, this option only works if you're confident that you have a steady level of overtime work. I want to mention a particular exception here that may be relevant to some of our nonprofit employers. This has to do with the effective date of these new rules. We all know this is coming up on us pretty quickly, December 1st. There is a category of employers who are given an extra 28 months to implement these. March 2019 will be the deadline for them. It's the providers of Medicaid-funded services for individuals with intellectual or developmental disabilities in residential homes and facilities with 15 or fewer beds. So for these employers, as it relates to those employees, you will have an extra 28 months to implement the new rules. What happens when you have an employee who becomes non-exempt, perhaps because they don't meet the new salary minimum? Again, whether they're salaried or hourly, they're going to be subject to the same wage and hour rules as all other non-exempt employees. That means you've got to maintain accurate time records, even if they're never working any overtime. We'll talk for a minute about what we mean by accurate time records, because the Department of Labor's view, it's not enough, and we would agree, for an employee to be asked to hand in a timesheet at the end of the week and to fill in 40 hours. What the Department of Labor requires are contemporaneous and accurate time records. So that means every day the employee needs to input the actual time that he or she worked. It can be done through a time clock, or it can be done through timesheets. Any method is acceptable, but it has to be reflective of actual hours worked, not what the schedule was, what they were planning to work, what they usually work, or a standard level like 40 hours. So a timesheet has to be contemporaneous and accurate. In addition, as with your other non-exempt employees, a newly non-exempt employee, you got to keep track to be sure that they're paid for all their hours that are worked. Obviously, if they work overtime over 40 hours, you're going to pay them that time and a half. That's the bottom of the slide. But in the middle is an area that is worthy of consideration, which is you're responsible for paying for work off the clock work, right? If you're aware or have reason to be aware that you have employees who are clocking out or signing out but continuing to work, whether they've been asked to do it or not, if you're aware of it or should be aware of it and allow it to happen, you're going to be on the hook for all of that time. Meal breaks. As you may know, in Massachusetts, a 30-minute meal break for somebody who's worked 6 hours or more is required. It's not required to be paid, but here's where you need to pay attention. The meal break is required to be a break, and that means the employee is relieved of his or her duties. They're free to leave their workstation, and they're not working. Just like the off-the-clock work, after a shift or before a shift, if you are aware, your supervisors are aware or should be aware and are permitting employees to work during their meal breaks, a portion of it or the entire meal breaks, you've got a wage and hour violation, and you're looking at potential damages. The meal breaks are an area that requires close supervision by managers, and need to be sure that not only are people punching out or noting that they've taken the meal break, but they actually take it. You don't want to have a system in your payroll system that automatically deducts the meal break, because, again, the Department of Labor wants accurate records showing what an employee did on a particular day, not that they were scheduled for a break from 2:30 to 3 p.m., but that they actually took it and were relieved of their duties. Travel time to conferences or training, it's an area that often see issues come up, needs to be compensated generally. Likewise, with technology advancing as it is, we're seeing a number of questions about work performed on remote devices, whether it's a smartphone or a laptop at home, remote access to files or charts or client materials. Work is to be required to be paid regardless of where it's done, right? It could be done from home. If it's work that's benefiting the employer, whether or not, again, you've asked somebody to do it, if you're aware they're doing it, it's compensable time and has to be paid. All right, we've talked about the overtime premium. This next slide is just a graphic of some of the considerations when you are increasing somebody's salary in order to maintain their exempt status. First, the left box is the key again. You want to make sure that you're looking at their duties. If there are duties that are part of their job that might threaten the ability to argue that their primary duty is an exempt one under one of the exemptions we've discussed, think about whether some of those non-exempt duties can be shifted to somebody else to bolster your position that this is a person who meets the duties test under one of the three core exemptions. So it's the first item, confirm that their duties that are required of them qualify for exemption. Make sure that the job description includes the actual job duties. We often see organizations have dusty job descriptions from decades ago, or at least years before, that are not reflective of reorganization, growth of the organization. They need to reflect what your employees are actually doing. Make sure you have a plan to communicate to these employees why their salary is being increased. Talk in a minute, there's going to be a fair amount of attention to this, I think, as we get closer to December 1st. People understand that there's new federal overtime rules. That's a fine explanation as to why somebody's getting a salary increase. But you need to be anticipating the question. Make sure they get written notice of their new salary, and make sure that it's reflected everywhere, not only in their paycheck, but payroll records, wage statements, withholding purposes, all of the entries that are affected by the salary rate. And make sure that your HR and your managers are ready to answer questions about why there's been an increase. As I mentioned a minute ago, they need to equally be ready to answer questions from other employees about why they may not have received an increase. And this relates to the potential claims that could arise during this transition period. First category is an employee who is exempt today because they meet the current threshold, and they will be exempt tomorrow or December 1st because they will also meet the new threshold, right? So they're making more than the 980, the new required minimum of $913 a week. They may see some coworkers who've gotten a raise. They have not gotten a raise because they're already over the threshold. Second source of potential claims has to do with exempt employees, such as those we're just talking about, whose pay you might have raised to meet that salary level requirement, but who think that they should be reclassified as non-exempt and therefore eligible for overtime based on their duties. And again, this could be somebody who has been treated as exempt for many years because the employer thought that all they needed to do to make them exempt was to pay them a salary as opposed to hourly, and had never looked at the underlying issue of compliance with the duties test. The attention to overtime rules is going to alert many employees, as well as lawyers who work in this field, and lawyers are going to enter this field because of the attention. All these folks are going to be paying new attention to all of the prongs of the exemption, particularly the duties test. And so you may have employees who say, well, I've read about these new overtime rules, I've looked at my duties, I don't think what I'm actually doing qualifies for the executive exemption or the administrative exemption or whatever it would be. Third category are reclassified employees who ask you why they weren't classified as non-exempt and paid overtime from the start of their employment. People who, when you look at their duties, you're going to say, well, actually, we want to be sure that we get you your overtime that you're owed, we're going to start paying. That might well prompt the question, why now? Why haven't I been paid it before? And there needs to be a careful strategy about how to respond to those questions and how to roll out these changes in a way that is likely to minimize claims and to clearly communicate to your employees why they are now getting overtime in this category and why they have not in the past. Equally important are employees who might say that I had worked in the past off the clock, or I've missed my meal breaks, or worked through a portion of my meal breaks, or my past overtime was not calculated accurately. You may find, as I say, particular attention to these issues as we approach December 1st and be seeing questions like this from different categories of employees. The concern is that we're going to have a surge in claims, a wave of these claims, right? The coverage about this effective date is going to draw attention to these issues. A number of lawyers who may practice in other areas are going to become interested in this area, both under the Federal Fair Labor Standards Act and state law claims. You'll also have inevitably talk among your employees about overtime and overtime compliance. This is going to happen. It's not something you can prohibit, and this is an important point. A separate federal statute, which has to do generally with union organizing, the National Labor Relations Act, but applies to every workplace, union or non-union, prohibits employers from barring employees from having these discussions. You may not have a policy or instruct employees that they cannot share their salary information, their compensation, whether they're getting overtime or not getting overtime, with fellow employees. Those discussions are protected and may not be prohibited. Okay, this step chart is supposed to reflect, if you haven't already gotten the message, this is an area that attention needs to be paid. This is the number of Fair Labor Standards Act cases filed in the federal courts over the period 2000 through 2015. We expect the figure for 2016 to be higher still, and as we get into the new year after these new rules, increasing further. These cases are not theoretical. There have been a number of recent settlements involving overtime violations. I'll give you a few examples. This is a small case involving a company called Best Air Compressor Services. They had only 13 employees who were working more than 40 hours a week but not getting the overtime pay. They had misclassified salaried managers as well as some clerical staff as being exempt from overtime. And again, this is reflective of this common misconception. I don't know this particular company, but I'm guessing that, like many, they figured if we give the title to somebody of a manager, call them a manager, we give them a salary, that's all we need to do. We don't need to look to see whether their duties qualify them for the exemption. And again, the title manager is all well and good, but in a case challenging failure to pay overtime, the courts and Department of Labor are going to look at are the realities. Many cases involve folks who have a managerial title, assistant manager, but are nonetheless found to be non-exempt and required to be paid overtime. The settlement here involved a mere $13,000 for these 13 employees. However, look at some other recent settlements, and this one is on a national basis involving the Bloomberg company. It had to do with their customer service employees, claimed they were not paid overtime. One of the plaintiffs, a woman named Jackson, was claiming that she worked 10 additional hours per week without pay. How did she identify or specify those? She said that she was expected to come into work earlier, before her shift, and start working. She was leaving after her shift, after she had punched out, working again off the clock. She claimed that she was working from home again after leaving the office, and that she worked through her lunch break. This case, Bloomberg settled for $3.2 million. Closer to home, Labor Department found violations involving some construction firms here, a $2.4 million settlement. Interesting point here is that the bulk of the employees had been misclassified as independent contractors. And I mentioned this area earlier. It relates to overtime pay, because if somebody is treated as a contractor rather than an employee, as they should have been, they're not going to get overtime because they're getting a contracted rate and you're not even tracking their hours. The Department of Labor here alleged that that exactly was the purpose of these decisions by these construction firms to treat employees as contractors to avoid paying overtime and other benefits, such as employment, health insurance, workers' comp. This is an area of significant enforcement focus for the Massachusetts Attorney General as well as the Department of Labor. And as I say, it has implications for overtime claims. These particular companies were engaged in another illegal practice, which was cash payment combined with payroll checks to avoid paying overtime. And they were also penalized for not keeping accurate time records of when their employees were working. I'll say one more thing about the independent contractor issue, which is, for those of you who have operations in other states, you'll know that Massachusetts has a particularly rigorous test. It is very difficult under Massachusetts law to have individuals properly classified as contractors. I've seen a lot of questions about this in litigation. If you have somebody who you're treating as a contractor and you're not sure they qualify for the Massachusetts test, it's certainly something worth looking at, because again, the exposure can be significant, automatically trebled. Another example, Dollar General stores, retail setting, folks who were labeled store managers, they were held not to be eligible for the managerial exemption, executive exemption, or the administrative exemption. The allegations there is that they were working as many as 90 hours a week, and they were spending about 10% of their time doing managerial work that might have satisfied the qualification if it were their primary, might have satisfied the exemption if it had been their primary duty. But in fact, only about 10% of the time were they doing managerial duties despite their lofty managerial titles. Rather, according to the complaint here, most of their work involved tasks that were non-managerial. They were actually operating cash registers side by side with the employees whom they were purportedly supervising. So again, courts and the Department of Labor is going to look behind the labels. They're going to see what people are actually doing. And here, this was an $8.3 million settlement for almost 3,000 employees. Question has come up, is this rule actually going forward? There have been some political efforts to block it. Those have not borne fruit in Congress. There is, however, a piece of litigation some of you may have read about. I don't think this changes anything, but I'll let you know about it as well. This was just 10 days or so ago. 20 states led by the Nevada Attorney General filed a lawsuit challenging the legality of these new rules. The vetting from those who have followed the case and looked at the claims is this is not going to delay the December 1st date. So the advice we're giving is that everybody should be planning that these rules will take effect on December 1st as scheduled, and that you have a plan in place before then to ensure that all of your employees are being paid in compliance with the new rules, overtime, as well as for all the hours that they are working. We're going to take a look now at some of the questions that have come in and see if we can address some of those that would be of interest generally. So first had to do with, I mentioned nursing, and and that's a good example of where this line is drawn as it relates to professionals and non-professionals. Both registered nurses and licensed public nurses, licensed practical nurses, LPNs, are going to be considered professionals. As you might expect, though, certified nursing assistants, CNAs, and other aides are not going to be are not going to be considered professional. So the line is drawn below LPNs and above CNAs for the nursing setting. Question that comes up frequently is, I've got a part-time employee. They make less than $913 a week, but if I were to prorate that figure, multiply it by what they would make if they were making, if they were working 40 hours a week, would that be enough to satisfy the salary threshold? Answer is no. The Department of Labor does not allow that prorating. They're looking at the actual dollars the employee is earning. So if it's a part-time employee and they don't make $913 a week, they're not going to satisfy that element of the test. Let's see. We've got a question about a manager who is properly exempt but fills in as direct care apparently some point during the week, right? So we've got, I think the question seems to be, can we pay that person their flat exempt rate? So you can certainly pay any rate for that direct care work that meets the minimum wage. You can calculate it based on their salary for their other work. The question is going to be, there's an overtime question here, right? If somebody's filling in work puts them over 40 hours, you may be looking at overtime exposure, right? So it depends on the mix of hours. But if they're working, for example, full-time or close to full-time as a manager, but fills in direct care basis on the weekends, and that puts them over 40 hours, they're going to have to be paid a time and a half for those 40 hours. So the question of what base pay rate you assign them is going to be an important one, because you're going to be paying 1.5 times that for all of those overtime hours. We have a question about a faculty member who makes less than the threshold. And this may implicate both the professional duty exemption, and it also may relate to another set of exemptions that relate to higher education employees, and those are a totally separate category and don't need to meet as many of these requirements. So, for example, department chairs, or coaches of teams, teachers even, both higher ed and secondary education, are automatically exempt regardless of how much they make, sort of like lawyers and doctors. They're considered professionals automatically. I'm not sure from this question the references to a studio technician or a faculty member. It's certainly worth exploring whether that position would meet the professional exemption, one of the higher ed exemptions, possibly even the creative professional exemption. We need to know what the job responsibilities are. Let's see. We have another question. Regarding the decision-making around increasing somebody's salary if the duties test is passed, or making them hourly to save money. Do we need legally to be consistent across the job title or across the company? So we would certainly recommend consistency across the job title if everybody is doing the same work. There's no requirement that you be consistent across the company. You can have positions which, after your review of them to ensure they meet the duties test, are classified as exempt, and others that are classified as non-exempt. And again, the question says, should we make them hourly to save money? whether they're hourly or salaried, if they're non-exempt, they're going to have to be paid overtime for any hours over 40. Again, it's going to be a mixture of looking at what their duties are, what their schedule is, how frequently they work on an overtime basis where they work the hours over 40. We had a question about the computer employee exemption, and I'll give you a little more detail on that. The compensation level is the same as these new, the ones we've been talking about, but that person has to be a computer systems analyst, a programmer, a software engineer, or some other similarly skilled worker in that field. So a technician who is not going to satisfy that. They have to be involved in such things as design, development, analysis, testing or modification of computer systems or programs. And there's a mix of duties that can meet this, but that's the level, those are examples of the level of work that that person would need to be performing in order to satisfy that particular exemption. How much of one's duties is required to define it as primary? Very good question. We have an employee who does a lot of administrative, grant writing, design, and office work, but also manages on-site labor projects. So how much of the time needs to be in the former category to count as primary? Unfortunately, we don't have a definitive answer set in terms of the percentage of hours or minutes in a day. Courts and the Department of Labor look at is sometimes they use the term predominant, sometimes the steps, the regulations talk about primary. The focus is really what's the core of the responsibility and what responsibilities are peripheral. Certainly if somebody is doing 80% work that requires exercise of discretion and judgment on matters of significance, that's likely going to satisfy that exemption. Particularly, for example, when you say they manage on-site labor projects, if that responsibility is sporadic, it's unlikely to interfere with their eligibility for the exemption. If, on the other hand, the job description and their review of their schedule would show that 1 day out of 5 they're out of the office doing work that does not satisfy the exemption, you're going to be a lot closer to the line, and that may well render them non-exempt. So it's case by case, as I mentioned, talking about the example of the admissions staffers at schools. Cases sometimes come out differently despite the job titles being exactly the same, because we're looking, again, behind the titles to the actual duties and responsibilities. There's a lot of guidance out there from the Department of Labor. They issue these opinion letters. They tend to be very helpful and specific to different job titles. When reviewing job descriptions or positions to help you assess whether they meet these exemptions, we look both at those as well as the regulations and the case law. A lot of these cases have made their way to the courts, so we have guidance from federal and state decisions interpreting similar positions to the ones that you might be inquiring about, and that's really the best way to get comfort that you're in compliance, is for us to be able to point you to a court or a Department of Labor decision which confirms that you're on the right side of the line and that your employee meets each of the elements of the exemption. So we're coming to the end here. I want to mention just a couple of things. We have a number of other webinars that we'll be presenting over the next months. You'll get notice of those. Today's webinar, including the slides and the audio, will be posted on the Krokidas and Bluestein website, which is kb-www.kb-law.com, which is there on the slide. We are happy to answer questions that you may have that may have been prompted by something you heard today or an issue that you're dealing with that is specific to your workplace. You can reach me at the contact information that's provided there. Myself and my colleagues in our employment law practice are happy to address questions as whether they relate to overtime or some of the other employment law issues that we mentioned at the outset. Hope this has been helpful. We appreciate all of your participation today, as well as the questions have been terrific, and we thank you for joining us for today's webinar.